Hey, Mark, do you want to kick this off? It looks like we have about 144 people on.
Okay, well, I guess we are ready to roll. We'd like to walk through what we currently understand this Act 185 to be or do, although there are still questions that are coming into play. And then hopefully have a dialogue or at least Q&A sort of thing with how this thing could happen, might happen, what some of the landmines are in this, and how they might be maneuvered if they can be maneuvered. So I guess we'll start off with, Andy, are you going to walk through the presentation on screen, and then we're going to, or no, we don't have that presentation on screen, but are you going to kind of walk through, or maybe Kyle, you're going to walk through how we got to where we are, and then Andy, you explain how it is we currently understand 185, and then we'll open it up to conversation. So Kyle, go ahead.
There you go.
Yeah, thank you, Mark, and thank you, everybody that joined today. I know that we kind of threw this together relatively quickly, and the reason being was that since the Assembly passed their legislation Tuesday, the Senate passed the bill Wednesday, and the governor signed what is now Act 185 on Wednesday, the associations received a number of questions concerning the property tax changes that were included in the Assembly bill, which is now Act 185. I'll walk through a little bit of the history here, how we got to where we are, and then I think we'll turn it over to Andy to talk about some of the technical aspects. And then we're joined today by the state treasurer, who's going to talk about some potential financing options to assist counties with some of the challenges that this act presents. But the history of this really started with, we had a couple of mayors of large communities around the state that indicated they would like the ability to delay some of their installment payments in an effort to provide taxpayers a little more time to pay their property taxes. Those discussions partly led to Governor Evers in the two bills that he had proposed the legislature take up relating to COVID. In those bills, the governor had proposed waiving interest and penalties if property taxes were paid by the end of the year. Those proposals were not acted on by the state legislature, but the legislature did draft their own bill. And in the original bill that was released from Speaker Voss and Senate Majority Leader Fitzgerald, the original bill allowed a taxing jurisdiction to essentially pass a resolution and waive interest and penalties if property taxes were paid by October 1st. One of the concerns that the association had with that language was there was no change to the August 20 settlement date, whereby counties are required to pay other taxing jurisdictions in full the taxes that they're owed. So you could have had situations where a municipality, a city, village, or town, essentially delayed property taxes to October 1st, yet the county would have no say in that and would be still required to settle on August 20th, even though we likely wouldn't have sufficient funds given that taxpayers could wait until October 1st. So we worked with legislative leadership over the weekend and throughout the day on Monday on the amendment. So if you look at the legislation, there was Amendment 4 that was offered in the State Assembly and was subsequently adopted by the Senate. But that amendment made some tweaks whereby counties have to first authorize allowing municipalities to delay payments. So I think this is important in that counties ultimately are the decision maker as it relates to Act 185 and delaying property taxes to October. If a county does not pass a resolution, no community can adopt the interest and penalty waiver, and nothing changes. Property taxes continue to be due on July 31st, and the full settlement will be made by the county on August 20th. Now there's some changes regarding settlement if the county does pass a resolution, and maybe that's where I'll turn it over to Andy to talk about kind of the process and the bill language specifically.
Sure, thanks, Kyle. And let me just start at the top, because I think if we start at the top of the language, if we walk through the statute, we can see some of the issues and concerns that come through that interpretive guidance. I think is going to be helpful from DOR. Kyle, I want to mention too that you and Mark have been in contact with DOR, and DOR has committed to work with counties and with municipalities to reach an interpretation of this new provision that is going to be functional In other words, it's not going to be parsing each and every word within the statute to figure out the dictionary definition and application of that definition to the statute, that it's going to be a much more practical interpretation. So thanks to you and Mark for leading the effort on working with DOR on that. So as I go through this and identify some of these issues, just know that there's a lot of work going on in attempting to provide some clarity here on what this statute really does. And so if we start from the top, it talks about this whole concept of defining a hardship and defining what happens in the event that there's a hardship. As Kyle mentioned, it's a resolution process on defining what this hardship is. And so if you look at the language of the statute, it says that after making a general or case-by-case finding of hardship, a taxation district, that being a municipality, has the ability to provide that there's an extension of any sort of installment payment that is otherwise due, extend that out to October 1st. As Kyle mentioned, that taxation district provision providing that the delay occurs doesn't happen unless a county has first adopted a resolution authorizing the waiver. And so when we think of the county resolution, it is an enabling resolution. It enables the taxation district. It doesn't require the taxation district, but enables the taxation district to then also have a resolution that would delay the payment and also waive interest and penalty. Now, going back to the first part of the new statute, the new law, it talks about a case-by-case finding of hardship or a general finding of hardship. If a county adopts a resolution, and if a county is going to authorize a case-by-case determination of hardship, then the county has to establish the criteria by which the taxation district is going to evaluate the case-by-case hardship. If the county, on the other hand, is just going to authorize a general waiver for all property taxpayers, then I think that the finding of hardship and the criteria for establishing that hardship are self-evident. We have a COVID-19 crisis. We have record levels of unemployment now going on throughout the state. And so I think it'd be very easy to demonstrate hardship on a general basis. It's where you get to the case-by-case determination that is problematic. I'll say that I have a very, very challenging time giving legal advice to folks about what a case-by-case hardship determination would look like, because we have several constitutional issues that come into play. Uniformity of taxation, equal protection under the laws. All of those concerns lead me where if somebody were asking for my legal advice, I would say don't ever do a case-by-case hardship analysis, because it's just too wrought with peril. And so I think we're more talking about the general finding of hardship. So again, the county establishes that resolution, enabling the local taxation district then to waive interest and penalty and delay that installment payment to October 1st. Now, getting back to this whole question of, well, what is an installment payment? Because we've had discussions, and I know that the Treasurers Association has had some discussions as well, which I'm glad Mike is on the phone and he can maybe address some of this as well. Question is, well, under the normal circumstance, under 74.11, we have a choice by the property taxpayer. You can pay in full on January 31, or you can pay in two installments, January 31 and July 31. So is the July 31, is that considered an installment under this new law? In our estimation, it is. It is because in this new law, it specifically references 74.11. We think that that reference would be superfluous unless the July 31 payment were considered to be an installment. So we do believe that if you're in a county and you have a taxation district, a municipality that's not adopted an ordinance that calls for payment in installments, in other words, you're under the standard state statute process, that nonetheless, that July 31 installment is going to be considered an installment under this new law that would then be eligible for waiver of interest and penalty and delay of the due date to October 1st. When we talk about the impact or the effect of the county resolution, that's where this law gets a little bit confusing too, is that the way we read this law is that if a county adopts a resolution that would enable or authorize a taxation district to waive interest and penalty, it doesn't matter whatsoever if any municipality or taxation district within the county even grants a waiver, even grants the delay, that still moves the settlement process out a month. What does that mean? Well, if you look at the language, it says that if a county adopts a resolution authorizing the waiver, then the August 20 settlement just becomes, we're going to settle on money that we've received by July 31. Money we've not received by July 31, we don't have to settle on. And so then on September 20th, in other words, it bumps out a month, on September 20th, then we're going to settle on the balance of those taxes. So again, even if no municipality within a county's jurisdiction authorizes or grants any waiver, if a county has a resolution on file, it still extends that settlement date from August 20 to September 20 on the taxes that have not been paid by July 31st. I think there are some questions that still remain about this, because if you look at the language of the new law, it discusses a concept of waiving interest and penalties. It does not say that the taxes are not delinquent. In other words, we can waive interest and penalties, but that doesn't mean that we're changing the statutory due date for these taxes. That's important because we know that under 74.57, we have a September 1st date for issuing a tax certificate on properties that have not paid their taxes by the due date. And so there's a question about whether that tax certificate will issue even for those properties where interest and penalties have been waived until October 1st. I say it's a question because it's challenging. I've taken a look at this. I won't tell you I've spent the last 24 hours studying it, but I've looked at it pretty extensively, and I don't see a statutory existing law workaround for that September 1st date. Again, I'll go back to what I talked about at the very beginning, and that is that DOR is working with us to try to find a practical solution for application and implementation of this law. So I don't think that we're going to have a situation where all of a sudden we have all sorts of properties showing up on the tax certificate that otherwise have deferred, so to speak, their interest and penalty until October 1st. But the way that the statute operates right now, the way the new law reads in print, that is a concern and that is an issue for us. The other issue that's out there that we've heard or we've looked at and discussed is this concept of, well, what does it mean on August 20 that we settle on the taxes that have been paid? If you look at the language of the law, it says that the August 20 settlement shall be distributed proportionally to the underlying taxing jurisdictions. I think you can make an argument that, well, proportionally just means that we share it equally among the underlying taxing jurisdictions. Well, that would lead to inequity for a jurisdiction where property taxpayers have paid in full by July 31st because for whatever reason the municipality did not want to defer interest and penalty and kept the due date. And then you've got another municipality that said, sure, we're going to waive and we'll let you pay by October 1st. There would be a severe inequity for those taxing jurisdictions that did not extend the due date, so to speak. The way we think this law reads, if you read it in conjunction with the definitions under 74.01, is that proportionate distribution means it's based upon the properties that have paid their taxes within the taxing jurisdiction. So in other words, you take a look at the properties within a municipality that have paid the taxes, that municipality's settlement is for the properties that paid their taxes. That's how we think that's going to be applied, but that again is another issue that the Department of Revenue is going to be looking at. I think for now, that's basically the overview of how the law works from a county standpoint and some of the pockets of concerns and issues that we've identified to date where those are. So Kyle or Mark, I don't know if you wanted to talk about anything having to do with our conversations with DOR, but I would be interested in Mike's take on some of this as well.
Yeah, and Andy, maybe before we turn it over to Mike, do you also want to talk about kind of the case-by-case waiver piece and who would be making that determination? I think we have, like Andy said, I do not think that we will be advising counties to, if they're going to do this, adopt the case-by-case hardship determination. We think that's fraught with legal challenges, so you're probably better off doing a general waiver. But in the event that a county does define hardship on a case-by-case basis, we believe that it would be the municipality that would essentially have to make that determination, not the county.
No, that's right. If you look at the language of the new law, it talks about the county resolution establishing criteria for determining hardship. And so you would put factors in there about what a case-by-case hardship determination is going to look like and what's going to happen. So it would be up to the municipality then to apply the criteria provided in the county resolution to each particular property owner that is seeking a hardship exception. So yes, the county is not making that determination. It's the municipality making that determination based upon the criteria established in county resolution. It looks
Mike,
like you got it. I'm sorry, go ahead, Kyle.
Yeah, I guess we have a question here. Isn't there a problem with the September 20th settlement date and October 1st payment date? Yes, I think there's a few things that a county needs to consider, before deciding whether or not to move forward with this. But I think the biggest challenge for a county is going to be, in the event that a county passes the resolution, you are still going to have to settle on September 20th, but will you have sufficient funds to do so, given that a large chunk of property taxes may not come in until October 1st. So that's why we're exploring different financing options, but we're also joined today by the state treasurer, Sarah Godlewski, who's going to talk about the potential for BCPL possibly providing some low interest short-term financing for counties. But before we turn it over to Sarah, Mike, did you want to make a comment?
Yeah, Kyle, let me
No.
This is Mark. Let me just add something before you get to Mike. This is one of the challenges with this piece of legislation that counties need to be fully aware before you walk into it. Under normal circumstances, we have majority taxpayers paying on a January and then a July payment date. And then we have money for half a month or so, and then we settle on August 20th with all our other taxing jurisdictions. Under this new scenario, so in other words, under the old scenario, we get the money and then we settle. Under the new scenario, with the changes and how we're interpreting, we would settle and then get the money, meaning that every county would have to go out and acquire dollars or take them out of your pocket to settle and then receive the final installment payment of October 1. That's a very different mechanism, and it would require either dipping into a fund balance, issuing a short-term note of some sort, looking to BCPL. We had asked the state to give us a loan out of the general fund. So in our effort to assist businesses or individuals who may be under hardship, and again, how we define hardship, it's difficult, and allowing people to pay their taxes later, it will cost the county money, unless we can get a 0% loan, but it will cost the county dollars. So you just need to the counties need to be aware of that walking into this. So just a little addition of what Kyle had indicated. So Kyle, back to you, and I think, is Mike going to give us a perspective?
Yep. So one comment, or one broad comment, I guess, with regard to how this works and how this is applied that is different from the norm. And I don't think Andy touched on this, but those, if the county goes and does the initial resolution, and then subsequently the municipality does a similar resolution to do so, payments that are then deferred, if that's the right language, interest-free until October 1st. The one thing I don't think was mentioned yet is that there is a different interest and penalty calculation beginning on, I assume, the 2nd of October that is different from what we as county treasurers typically do. So under normal circumstances, July 31st comes, statute, I believe, indicates The technical due date is January 31st. However, if you do not pay your second installment in full or on time, interest and penalty charges go back to February 1st, and you in essence pay the statutory 1% and the 0.5% county option for those 7 months, February through August, so 10.5%. The way this language reads is that the interest and penalty charges change from February 1st to now beginning at the statutory 1% and potentially up to the county 0.5% penalty charge on October 1st. So there's a significant difference, you know, in the calculation of interest and penalty payments. So that I guess is one blanket clarification I'd have. I think the other thing that's important is that, you know, given the way this potentially can be done, you have a county that chooses to adopt the resolution, and then you potentially could have City A that says, yes, we're going to do the same based upon our general interpretation of hardship for our constituents, and municipality B does not. And I think we'll find it oftentimes that people that own multiple properties also in the same county also potentially own multiple properties in different municipalities. So there's going to be some some things that we're going to have to understand, that in certain scenarios, yes, the payments are deferred, but in other scenarios, if they, you know, the municipality does not adopt the resolution, the payments are not deferred. And so that will be somewhat difficult, I think, from the treasurer's perspective to navigate through and fully understand and fully know while they're in the collection process as to which ones this law applies to and which ones it does not. I don't know if there's any other things. I think, Andy, you did a great job covering, you know, what we're trying to accomplish, or what the law is trying to accomplish on the benefit of all, and the process and the sequence of events that needs to happen, both from the county standpoint and the municipal standpoint, as well as the settlement and the issuance of the tax certificate.
Thanks, Mike. I think your point on the interest and penalty calculation is a very, very good point, because one of the concerns here is making sure that our systems reflect what the law either requires or we think it requires. And that's where, again, it would be helpful to get some guidance from DOR on the application of this law. So those are very good points, Mike. I don't know, Kyle and Mark, if we wanted to try to answer some of the questions that are here, or if there are other points that you wanted to make.
Yeah, I did answer 2 of the questions. If you click on the Q&A, you'll see an answer to a couple of the questions. But Andy, this one's probably for you. Will there be an example of a resolution that counties can go by?
Yeah, that's a great question. I think that we as an association are prepared to offer a template that would apply a general waiver. As indicated earlier, there is no template for a case by case. I see there's a question on the screen from Brown County about having an application process for a case by case hardship waiver. That's fine, but I think even if you have an application process, you still have to establish the criteria by which a taxing district is going to judge, if you will, hardship. And so the resolution ought to identify what those criteria are going to be. I would assume there has to be an application process. Otherwise, I don't know how a municipality would get through a hardship determination. So I would think there would be an application process for that. But again, I would recommend as a lawyer that you not do a case-by-case hardship, because I think it's too dangerous. Legally, it's just far too dangerous. And so I think if you're going to do any sort of waiver or consider this, that it ought to be general across the board, or it ought to be no waiver at all.
And then I know we've got a couple of questions here from Terry and Kathy regarding communities where you only have the 2 payments. You have a payment due on January 31st, and then you have a payment due July 31st. And typically that July 31st payment would be made to the county. So in the event you're in that circumstance, does the municipality still have to pass a resolution? It's our understanding, and in talking with the Department of Revenue, that likely yes, the municipality would still have to pass the resolution, even though the county is the one who is essentially the collecting agent on that July payment. Those taxes are municipal taxes, for lack of a better term. So the county may be collecting them, but they're doing so in some ways on behalf of the municipality. So we do believe that if in a place where you have taxes due January 31st and July 31st, regardless of whether the county is collecting those taxes, you would still have to have the municipality adopt a resolution.
I see. I'm sorry.
Go ahead, Andy. Go ahead, Andy.
No, I was going to move on to a different question. So if there's something you want to elaborate on, Mark, go ahead.
No, I was going to move on to this other question as well. This is something we did not talk to Revenue about in the past few days, but what about postmarked mail? And does the grace period apply to the October 1st deadline? It's a really good question. On the postmarked mail, gee, I don't know. Maybe we'll defer to the Elections Commission on this one. They have answers on that. But on the October, does the grace period apply to the October 1st deadline? That's a good question. We did not talk to Revenue about that. And Andy, do you have any thoughts on that?
Well, yeah, I looked at that. Under 74.69, it's a general timely payment mechanism that talks about the postmark issue. Now, the statute 74.69, it does cross-reference the payment statutes 7411 and 7412. I've got to think that it's going to apply to this new law. I can't imagine 7469 would not apply, but I think that's a good question, one we should see clarification from Revenue on.
I see we have a question here from Jennifer. How is this different than the norm, as counties usually settle in full in August and take on any delinquencies? I think here's the difference, Jennifer, is that under current law, property taxes would be due by July 31st, and on August 20th, the county would make the full settlement. Under this scenario, a county would be required to make the full settlement on September 20th, but property taxes wouldn't actually be, I guess, technically due until October 1st. So you essentially have the county making a settlement payment prior to all the taxes coming in. I think that's kind of the difference here.
I think that's right, Kyle. And I think that it's going to be an issue depending on what county you're in. I know that Jenny's in Portage County, so if people are looking for short-term loans, it sounds like Portage County might have some excess funding available. Kidding aside on that one, I think that some of the smaller counties are going to be have the potential to be hit really hard on this on a cash flow issue. The concern is the difference between September 20 and October 1st, because unless you have a bunch of property taxpayers that just out of the goodness of their heart want to pay early to make sure we don't have cash flow issues, you're going to have a period of 2 weeks where we have to settle up with a bunch of taxing jurisdictions within the county, and we just don't have the money to do it.
I see here Jeff French asks, if a county approves this resolution and only one city within the county collects taxes in multiple installments and they pass an enabling resolution, does the resolution apply to just that one municipality? Kind of two thoughts here, Jeff. If the county passes the enabling resolution, property taxes would still be due on July 31st for everybody, unless a municipality were to pass the resolution. In the event that one municipality passes the resolution, then property taxes just within that municipality would be interest and penalty free to October 1st. So you could have essentially communities within your county, Jeff, where some property taxes are interest and penalty free until October 1st, while you may live in a different community and your due date is still July 31st and interest and penalties would accrue after that. So it is on a case-by-case or municipal-by-municipal basis.
But add to that, Kyle, too, think about that. If you have one municipality within the county that decides to implement that and delay that due date, so to speak, the due date remains the same, July 31st, for every other taxing district within the county. that still means the county is only going to settle on August 20 with the money that's paid by July 31st. So even though a municipality says, we're not going to waive, we're not going to delay this payment date, the municipality still could get shorted, so to speak, under normal circumstance with their August 20 settlement, because the county's just going to deliver the money that's been delivered to the county by July 31st.
And that's an important point that I think we touched on, but I think we should follow back up on that. Is Andy's exactly right. But even in a scenario where if a county passes a resolution, that automatically triggers the settlement to September 20th. So a county could pass a resolution, even if not a single municipality within that county passed their own resolution, the settlement would still be delayed.
We have another question here that we haven't touched on. If somebody's already paid late and was charged and paid their interest, does that interest now have to be returned to the taxpayers? The answer is no. It doesn't impact anything going back in time. It's on installments. The enabling resolution that the law says on installments that are due after April 1st. We have a question.
So just to clarify, Andy, you have we had a March 31st potential deadline for some of those multiple or 3 or more installment municipalities where the county is not the collecting agent. If those were delinquent as of March 31st or April 1st, they are still delinquent. And if we have, I think going forward, if we have an April 30th potentially installment deadline or due date, and that is missed under the scenario that both the county and the municipality adopt those resolutions, then those are the taxes that are I guess, deferred interest-free until October 1st. I mean, just kind of a scenario to prove how this works. Things that were delinquent as of February 1st or March 1st or March 31st, those are still going to be treated as delinquent throughout and the same statutory and ordinance-related penalty and interest charges will be applied.
I see we have a question here from Todd. What are the chances the legislature would move the September 20th settlement date to October 20th? This would be a correction of an error they made. Todd, I don't think that, I know this was not an error. It was our request that if the legislature was going to do this and allow this, that the settlement date be pushed back to October 20th. They had no interest in doing that, and I think partly it was because of some of the cash flow issues that underlying municipalities or other taxing jurisdictions, such as a school district or a tech college, may have. So we were unsuccessful in getting them to move from September 20th to October 20th, and the legislature will not be coming back in to address this. So unfortunately, the September 20th date is the latest we were able to get them to agree to.
We had a question, Kyle, about whether DOR is going to give guidance on what a general hardship is or how it's defined in a resolution. And is there any concern that municipalities might have differing positions on what a hardship is? I think when we're talking about a general hardship, there should be no difference of opinion between counties and municipalities and across the state. The general reason for the hardship is the crisis that we have with COVID-19 and the economic conditions we find ourselves in right now. And so I don't think that DOR is necessarily going to offer guidance on what a general hardship is, but I think it's certainly something that between the counties association, the league, and the towns, we could come up with some good language about the general hardship.
And I also think on that item, Andy, so the county would be required to define hardship in their resolution. A municipality is then required to pass a similar resolution, I believe the language is. I think our understanding is that whatever criteria the county came up with, the municipality would have to adopt that criteria. Is that correct, Andy?
That's correct, yes. Or at least substantially similar. The law uses the word similar, and I think from our standpoint, for legal reasons, we would suggest municipalities just make your ordinance use the same, or your resolution, have it read the same as the county resolution.
I see we have a couple questions here regarding collection, where you have municipalities who may collect all the way up to July 31st. If this is delayed to October, who's required to collect? Mike, maybe I'll turn that over to you. That hasn't been discussed. It's not clear within the law. So I'm guessing that that's something that probably DOR isn't going to weigh in on either. So we may have to kind of figure that out on our own. But any thoughts there, Mike, as to who the collecting agent is going to be?
In my opinion, and I'm not the attorney, Andy is, but since it was not addressed as part of this law and or the change in law or addressed as part of this enactment, in my mind, if you have a municipality that is the collecting agent through July 31st and in essence turns over, if that's the correct language, to the county for the county to collect, I mean, I don't think that part of the process would change, in my opinion. The application of the interest and penalty charges, would be waived until October 1st or 2nd or what have you, with postmarks and grace period potential consideration. But I don't think the collection process, since it wasn't addressed, would necessarily change. At least that's my take.
No, that's my take as well. I would agree.
So with that, or go ahead.
I was going to say we have a question.
Oh, go ahead. Well, I was just going to say, Andy, that you mentioned that before, that the tag, so to speak, of being delinquent is also not addressed. Therefore, the issuance of the certificate, although awkward as it might be logistically, that you're potentially collecting property taxes interest-free after you have the authority to issue a certificate, as awkward as that is. The true, you're collecting payments interest-free. You're not moving a due date, I think is what you said earlier. So in my mind, if that's the scenario, the same holds true with the respective collecting agents, where municipality still is the collecting agent through July 31st, August 1st, because of the tax certificate and ultimately potentially the tax foreclosure process of those certificates. That part of it does not change.
Correct.
So with that, why don't we, people can continue and are encouraged to continue asking questions. But I think everybody on the call understands that probably the primary consideration for counties in determining whether or not they're choosing to do this is, will they have sufficient funds on September 20th to make the settlement? And we are fortunate enough to have Sarah Godlewski, the state treasurer, join us today, along with Tom German from BCPL, to talk about some options that BCPL may have to help counties with the cash flow issues. So with that, Sarah, thank you for joining us, and the floor is yours.
Well, thanks, Kyle. And I just want to say I wish I was here under different circumstances, but I know, as you guys are aware, do you do this for your county or not? The question is this also financially feasible, as you are really kind of managing this not only delay potentially in revenue, but also a decrease in revenue? And so what are those options? Because this is a really unique situation. It's not a capital expense. It's really bridge financing that you are likely going to be looking for. And so your options are, maybe you do have a rainy day fund, or you have an alternative revenue stream that you can leverage at this time. There is potential maybe for the bond market, but that's even in question today. We know a lot of people aren't participating in that. Does that really make sense too for short-term financing needs? Because there's a lot of fees associated with that, and the question with the Fed's facility and how that's going to look in the future. So I just think there's a lot of questions around, is that really an option for counties? And then the third piece that I just wanted to talk about today is the state trust fund loan program, which I know some of you are familiar with. And my goal today was to really reintroduce this opportunity, this potential financing tool, but to also answer questions and get feedback, because I think one of the things that we will look at is there a way to potentially repackage this program to address this unprecedented time, knowing that as a fiduciary of this fund, I do have obligations. And so I'm hoping too that we can maybe make this a dialogue, because we don't want to change things or look at readdressing things if it's not needed. But also want to make sure if we do things, it makes sense for you at the counties as you are weighing this decision. So I can send something more about this after the call, Kyle, but really what the state trust fund loan program is a fixed rate loan opportunity that are competitive. So right now, we are offering loans for 2 years that are at a 2.5% interest rate. I think the big difference with us is that there's no fees associated with this capital. So to take this money out, there's no fees. To process this money, there's no fees. And to pay early, there are no fees associated with that. We also do it really quickly. So you don't have to wait and go through all of these running the traps to make this happen. It's really a quick one-page application that we review and can provide money, I think, quickly within when it's needed. So that's really, I guess, the high level. And when we approve you in this locked rate, it's good for about 60 days. So that is an overview of the state trust fund loan program. I want to turn it over to Tom to address like any other specifics associated with that. And then again, hear from all of you, because if this is something that could be a solution, but there's other things that you're thinking of, we would like feedback and opportunities to consider that. Tom, what else? So I want to turn over to Tom, who is our executive secretary. Tom, do you want to fill any gaps that I might have missed on that?
I thought you did a great job. When we talk about no fees, there is no asterisk. It is absolutely no fees, no application, no underwriting, no credit rating, no fees, period. And without those fees, you don't have any of those other steps for financing either. We don't require that opinion of counsel, etc. So it not only takes the fees out of the equation, it takes those steps and time-consuming pieces out of it. The other part of it is, once you give us that one-page request, we put together an application that is specialized for your particular county. Lays out the resolution and all the other pieces to it. And from the time that we provide it to you, you have 60 days to get it back to us. But the interest rate is locked. You know what the price is going to be. You don't have to wait for, for bond sale day to find out what interest rate are you really getting. And from the date that we approve it, it's locked for another 4 months. And so technically you have up to 6 months of rate lock protection. And one of the things that we've been watching lately in the bond markets is that there are these weird days where things just jump. On one particular date, interest rates jump 2%. So if your interest rate on Wednesday was 3.5, on Thursday it was 5.5. It was just crazy. We don't do that. That's not how we operate. We try to work hand in glove with our borrowers to make sure that, in essence, we are proceeding along in a way that makes sense for both of us. When Sarah said fast, she means it. I mean, the fastest that we've ever gotten from the time that we were initially contacted to the date that we dispersed was 17 days, which is pretty fast in the municipal financing market. So. But I don't know what else she missed. For the most part, I thought she did a great job of summarizing how we operate. We've been doing this since 1871, and it's been a great program, and counties have been great partners in it. So,
thanks, Tom. And I guess, Kyle, just wanting to turn it back over to you and your members. We want to be helpful. We understand this is an unprecedented time, and so we want to make sure that we can think through this together if need be. So if there's anything we can do or other ways that we should be thinking about these financing tools or financing opportunities, we really want to do that. So turn it, I guess, back over to you and your members for questions or any feedback they might have for us.
Yes, Sarah, and this may be an unfair question, but do you have a general idea of what kind of rates BCPL could be offering for counties that are interested in pursuing that to help kind of bridge that financing piece?
So right now, the rate is for a 2-year rate right now is 2.5. We haven't done anything potentially for short term. I mean, we do have a statutory obligation of 2%. I believe Tom, and he can chime in on this, if we do go below a 2%, we would have to get, I believe, legislative approval in doing that. So the rate, and the rates also, so we would have to do, I think, some exploration on that end. Tom, do you want to maybe highlight that piece?
That's absolutely correct. That statutory floor of 2% has been around for quite a while. So for us to go below it, we would need legislation.
Kyle, you're muted.
I'm sorry, Andy. Thank you. I do know that time is of the essence for some communities around the state, given that they do have installment payments that are due April 30th. So for those of you that are interested in exploring the BCPL option, I would encourage you to contact the state treasurer and Tom as quickly as possible.
And Kyle, what we can do is after this call, we can put together this one pager that provides information, our contact information. And I guess as you get feedback from your members, if this is something that they want to further pursue or something for us to consider, I just want everyone to know that our door is open. And we want to really be useful in this time of need because this is unprecedented. And counties are the lifelines of our communities financially, and we understand that. So we want to be helpful if we can.
Thank you very much. So with that, Andy, why don't we go back to the questions? I know that you and I have been trying to answer a few of them, but do you want to kind of walk through some of the questions that either you answered, Andy, or are still left unanswered?
Yeah, let's just go down the list here. I like the question. There was a question about whether if we have a property taxpayer that is paid in full and paid interest and penalties and somehow does not qualify or is not able to take advantage of the waiver of interest and penalties, can we direct those folks to the legislature for their complaints? And I think the answer to that is yes, Kyle, unless you feel differently.
Nope, I agree with you, Andy. Is there anything else that we missed, Andy?
Yeah, I'm looking through the list here and I don't see a lot that we've missed. Oh, here's a good question. The new law provides that it's applicable to property taxes payable in 2020. Does this apply to postponed personal property taxes, which are collected by the municipality? I don't think it does, because I think it's just talking about the property taxes in 2020. I don't know, Kyle, if you have thoughts on that. That's not something we've talked about, though.
I don't. Mike, do you have any thoughts on that?
To the best of my knowledge, and I could be wrong, but I believe the postponed personal property taxes have usually, if not exclusively, a January and July installment payment. If municipal collections are, the 3 or 4 installments, that may be slightly different, but I guess I don't have the letter of the law open in front of me, but if it pertains only to, I guess depends how it's worded in your interpretation, Andy, if it's speaking only of, I know there's a difference in the statute about real property versus personal property. And if we're generally moving installment payments or providing interest-free installment payments of property taxes in general or specifically to real property, which would be what we know as land and improvements and things of that nature. So I know how it currently works. I guess it depends upon your interpretation potentially, and sorry to put you on the spot, of what the law is trying to provide.
I think that's a good point, Mike, and it's not putting me on the spot. We're trying to figure this out together, so that's okay. If we look at the way that the Act 185 reads, it just talks about, and this gets into another question that we have up here talking about, what if we had somebody who failed to make at least half of the payment on January 31st, therefore we get into a delinquency situation February 1st? What happens then? The way that Act 185 is written is that it talks about tax payments, and it doesn't distinguish between real and personal property. It talks about tax payments and the due date associated with those tax payments. And if there is an installment payment that is due after April 1st, then you can defer to October 1st and waive interest and penalties up till October 1st. So the reason that I was confused about the prior question is that it talked about postponed personal property taxes, and I wasn't quite sure about what the due date would be on a postponed personal property tax. But if we have that personal property tax being due in an installment payment after April 1st, it would be eligible. That would be my impression based upon this language of 185, because it does not distinguish between real and personal property tax. Likewise, if we have somebody that is already in a delinquency situation because they failed to make the required amount of payment by January 31st, this law does not do anything for that property taxpayer. The amount that's due and delinquent as of February 2nd would continue to accrue interest and penalty throughout. The only thing that this law does then is if there is an installment payment that is due after April 1st, it allows the municipality acting under the enabling county resolution to waive interest and penalty to October 1st. We have a question here about if I'm understanding this correctly, the actual due date would not change. So if the resolution passed both entities, when we send our installment reminders, we'd still put the regular deadline on the installment reminder as the due date, correct? Would you recommend that we put language about the interest and penalty waiver on the back? I don't know where you put the language about the interest and penalty waiver in terms of there's no requirement in the law that it be conspicuous or that, frankly, you even provide notice to the property taxpayer of the waiver. But again, if you look at the plain language of Act 185, you're correct. The due date for the tax has not changed. So take that for what it is, and that's something we've asked Department of Revenue for a bit of guidance on how we treat that. Question, what if you have no scheduled meetings but have a municipality that wants to participate and they have an April 30 collection date? How do we get a resolution done in such a short time, or would it be retroactive? Yeah. The only way to get a resolution done is to have a meeting, and you can meet virtually, and I know every county is meeting on Tuesday. So I know that there are meetings that are going to happen, but I don't know the particulars here associated with this question in terms of what county it is and the ability to gather a meeting prior to April 30. Can you make a resolution retroactive? I tend to think not, because again, I think it's an enabling resolution, but I haven't really thought about exactly how you would make something like this retroactive. I suppose there might be a way to do that, but I frankly haven't thought about how you would make it retroactive. Question, if the county does not do a resolution, then the August settlement would occur as normal. Is that correct? That's absolutely correct. For multi-installment municipalities, would they still settle for their collection on August 15, or would that extend to August 20? They'd still settle on August 15. This didn't change that process. This Act 185 procedure didn't change that. There's a question just about what we were going to address on the webinar. And Kyle, I don't know if you see that question. It's at 10:52 from McNamara. In the WCA email for the webinar, there's a reference to relevant language to be discussed, interest on late property tax payments. Is this a reference to a particular statute? Assembly Amendment 4, ask the question because Act 185 seems to amend statutes dealing with unlawful tax recovery. Just trying to clarify the reference. The reference, you're not going to find it in Chapter 74 in Act 185. This is all non-statutory language, so it's not going to become part of the permanent statutes for the state. So there is no statute that is being amended as a result of 185. They're accomplishing this through non-statutory language. Unless, Kyle, you're aware of something that's changed in statute that I'm not.
Nope, I think that's exactly right. This is non-stat language, so if you want to look at the language, one of the ways to do it is to look specifically at Amendment 4 that was taken up to the Assembly bill.
And the reference to sub 25 is a reference to sub 25 in Act 185, and it's actually Section 105, sub 25. Section 105 is all of the non-statutory language. Question here, so if a taxpayer was delinquent on their first installment and doesn't pay their second installment before October, the first installment that was due January 31 would be charged interest from February on, and the second installment after October would have to be calculated for interest starting in October. I believe that's right, assuming that you've got an enabling resolution from the county and then a municipal resolution authorizing the waiver. So I think that's right, because the first installment is delinquent. That doesn't change here. The second installment due July 31st, you calculate interest and penalties after October. Let me say this is a big but though, and this is where I'd like Mike to weigh in as well. It's my understanding that if property taxpayer does not pay the required amount by January 31st, property taxpayer is not eligible to pay the July 31st installment, that it becomes delinquent. And so I don't know.
Correct.
That's something that could happen.
I don't know that that necessarily applies, because the interpretation that we've long gone by is that the statutes view January 31st as the due date. However, if the first installment, if you choose to do installment payments and the first installment is both paid in full and on time by the due date, in this case January 31st, then property owners have the quote-unquote option to defer their second installment until July 31st. So in our procedural methods over the course, forever since I've been around and much before then, is that the property is delinquent then as of February 2nd, and there is no option for a July installment payment, that the property is already delinquent and already accumulating statutory interest and potentially county ordinance adopted penalty charges.
That was my...
If I'm understanding the question correctly.
No, I think you're right. I'm understanding that as well. We had a question here about the template resolution from the Counties Association and the timetable associated with that. I think we can get something out by Monday. And the only reason that I'm hesitating on that is that we're in a bit of obviously a time crunch, especially for those counties that have municipalities that have a due date of April 30 out there. And so we have a bit of a time crunch to get something out. At the same time, we know that the Towns Association, the League of Wisconsin Municipalities, and the Department of Revenue are attempting to get information out. The last thing that we want to do is have inconsistent information and guidance out there. And so we want to make sure that whatever we put out is consistent. In my view, if we're going to have a resolution, it is going to be a resolution authorizing a general waiver, meaning it applies to all property taxpayers within a particular taxing district. Fine. I also think, and this is just me based upon our initial review of Act 185, subject to further thought and discussion, I also think that the county resolution has to authorize waiving the penalty, because it's county ordinance that imposes the penalty. And I don't think that a municipality has the ability to waive a county ordinance. And so I think that the two required elements, if you will, for a county resolution are: one, establishing the criteria for a general waiver, and then two, waiver of interest under the county ordinance. On that, I think we can build out the resolution from there using those two required elements as the foundation. We may uncover additional elements to that to that resolution that we think ought to be in there for one reason or another, based upon discussions that we have with DOR and that we have with the league and the Towns Association. So let's say Monday, with an understanding that if we are unable to get it out on Monday because we're waiting for whatever reason for something from revenue, we'll get it to you as quickly as we can. But let's tentatively shoot for Monday. I don't know if Kyle or Mark, you have further thoughts on timing with that.
Yeah, I think that's right. I mean, we want to, as from the association perspective, we want to make sure that we're providing as much assistance as quickly as we can. But like Andy said, we've had initial conversations with DOR. We believe that their interpretation is going to be consistent with ours, but we want to make sure that there is consistent guidance coming out. So if potentially there's still questions or differing interpretations on Monday, we may wait until later to just get that ironed out, because we don't want to have to send out multiple communications that could potentially lead to confusion for either our members or municipal members.
Kyle, I don't know if you see any other questions or anybody sees any other questions that we might have missed here.
I have one question, Andy, if you don't mind.
Go ahead.
Is there a deadline or a drop dead date, if that's the right language, to pass such resolutions? I assume it must be by July 31st, right? But is there, I know it's critical now for April 30th payments, but is there anything to say that a particular county and then subsequently municipality can't do something in July and then, based upon language of statute, go back to April installments?
Yeah, I mean, that gets to the whole retroactivity question, and I think that's an interesting question and something we're going to look into further. I prefer legally to never have anything have to be retroactive.
Right, I agree.
But there's no due date within Act 185. I would say to you, Mike, how would you feel if the Calumet County Board took this up on July 30th? Would that make you feel comfortable?
No, absolutely not, and they would have my recommendation against doing it at that time frame. However,
right. So
I mean, that's worst case scenario, but I'm still thinking in terms of potentially mid-May, mid-June, mid-July even. The volume potentially, and you've had some calls, I think, statewide from the community and business or homeowners with regard to their hardships given the COVID-19, but for the vast majority of us, I think, that have the July 31st payment, I think, depending upon, again, all things that we don't know at this time, including how long this lasts, how the economy does or does not respond, the volume of concern will pick up as we get closer and closer to that July 31st due date. So I guess that was the impetus to my question that, okay, there's not a whole lot of conversation now because we're probably fairly early in the process going into this being about 30 or 45 days. But as time marches on and it becomes 60 and 90 and potentially the economy does not respond, I think the urgency will be, and the public motive will be a little bit stronger toward, midsummer potentially. So I'm just kind of trying to outline that scenario should we get to it. Hopefully we won't, but just trying to outline it should we get in that situation.
No, I think that's right. And I guess here's my impression is that it's driven, the timing of this is driven by a couple of things. Number one, when are the taxes due within any particular municipality? If you've got taxes due April 30 and the municipality wants to ensure that they are able to grant a waiver for those property taxpayers, then the county board unfortunately has to act relatively quickly to make that determination. Second, there is no deadline within Act 185, so it becomes a practical issue. And I asked kiddingly about Calumet County adopting a resolution on July 30th. That doesn't seem to give advance notice of here's what we're going to do, and so you have to revise your system to account for this. And so I think it has to be a discussion between the county board and the treasurer's office about what are we looking to implement here, and what is it going to take to do this, and how much time do you need. And then it's going to be a discussion between treasurer's office and then all the municipalities about that same concept. I think you're going to find that there will be, as we move along here in the next couple of weeks, either pressure or a lack of pressure from municipalities to take action. I think if municipalities become overwhelmed or flooded with requests coming from property taxpayers to take advantage of the Act 185 provisions, then you're going to see the municipalities saying to the counties, we need to do something, we need to act. We don't know that right now. There might be some out there that want to do that now, but I think we're going to have a much better picture of this in the next couple of weeks. And to your point, Mike, a month from now, we're going to have a much better, clearer understanding of exactly what the impact of this epidemic or pandemic is on the property tax payment stream.
And I think one other item to note that we'd recommend counties consider as far as timing, given that the county resolution automatically triggers the two settlement dates, the August and September, there could be ramifications for other taxing jurisdictions such as school districts who are expecting to receive all their taxes that are owed on August 20th. In the event that they're only going to receive on August 20th the taxes actually paid if a county passes a resolution, I think a county should give some consideration to some of the cash flow issues that school districts and other entities may have, and I think that kind of leads us to doing this on July 15th could create some real problems for them. So I think the sooner that a county can do this, so schools and other entities can prepare financially, I think would be in the best interest of the county. So with that, I don't think that we see any other questions here. Of course, if things come up later today or in the days following, please let the association know. We're happy to provide any guidance and answer any questions that arise. So thank you all.
Kyle, I'm sorry, real quick here. This is a question. I think this is a good point because we haven't touched on this. The new law mentions, quote, a taxation district may. And the question is, does this include the school district, special district, tech college? Do these districts also need to adopt a resolution? It gets back to your point, Kyle, about the impact on school districts. The answer is taxation district does not include those other entities. Taxation district is defined in the law as a city, village, or town. Taxing jurisdiction is the broader definition, including every entity that is authorized by law to impose a property tax. So again, this applies only to cities, villages, and towns within the counties that have to adopt that resolution. I just wanted to clarify that before we signed off.
Yeah, thank you, Andy. So again, any questions, please let us know. Feel free to email or call either myself or Andy. Again, we appreciate everybody jumping on the call today, and hopefully everybody has a nice weekend. Thank you.
Thank you all for your help.